Well, for all of you out there that are completely interested in the great, wonderful things of archives, this is another webinar coming from the Division of Archives here at the state of Utah. My name is Paul Tonks, and I get the unique privilege of doing the presentation for today. I am assisted by Renee, and you get to say hello, right?
Hi.
And but apparently next week is going to be a fun and exciting one as well. What are you doing next week?
Next week we're doing a virtual tour of the archives.
So that'll be a lot of fun, and so be sure to tune in for that.
Thank you.
All right. If you have any questions and things, apparently you can also be able to send them through the web links here. We'll be monitoring that throughout. But more than anything, we just want to make sure to be able to get you some good information. This is by a PowerPoint, and so the PowerPoint will be available afterwards. So take a look at things and see all the information that's presented. So with no more further ado, let's go ahead and get started then. Again, my name is Paul Tonks. I am an Assistant Attorney General with the state of Utah. I have been assigned as counsel for the Division of Archives and the State Records Committee since 2008. I now have the quite well distinction of being the longest serving counsel for the State Records Committee and the Division of Archives, besting the other person by about 6 years at this point. But it's a fun position. A little bit of my background. I have actually been practicing law since 1996. I started out in the state of Ohio, taking the Ohio bar back in 1996. I started out working as a staff attorney for the Ohio Court of Appeals, both the 10th and the 12th appellate districts, and I did that for about 5 years. I was also an assistant attorney general with the state of Ohio, doing that for 2 years. I worked for a private law firm, Perez & Morris, for about 2 years as well. But then the call to come back to Utah to family and things like that, we moved back to Utah. And I waved into the bar here, and I have been serving as an assistant attorney general with the Utah Attorney General's Office since 2008 to present. I do have a few other responsibilities besides being counsel for archives in the State Records Committee. I represent the Department of Administrative Services, the Division of Purchasing, the Division of Finance, the Division of Fleet Services, Office of Administrative Rules, also the Judicial Performance Evaluation Commission, the Transparency Committee, and a few other committees. And I've had other positions also representing the Department of Technology Services, Department of Agriculture and Food. So it has been a fun time for me serving here with the Attorney General's Office. But I have to say the most fun out of anything has got to be GRAMA, archives, government records, and how those all work. And I usually like to start this off with kind of a caveat because we are talking about legislative changes that are made to GRAMA. And I like to affectionately call GRAMA the third rail in Utah politics. For those of you not familiar with what is considered the third rail, if you have a subway system, oftentimes since you're down underground, you really can't have gas powered engines or anything that gives off any combustion. So you usually have an electrical system. And so you have the two tracks, and then you have a third track that's in the middle that has the electrical current. And a very important part about that third track, since it has electricity going through it, you do not want to touch that third rail because you will electrocute yourself and usually end up with death, which I hear is not a good idea in most instances. So GRAMA is referred to sometimes in Utah as the third rail in politics. And that's because anytime you try to make wholesale, large, big changes, it usually makes the news. One of the most notable ones happened back in 2011, where there were some large changes that were made. The changes actually came through late in the session. Many legislators actually said they didn't quite understand what changes were being made. It was called House Bill 477. And the uproar for that was so interesting that after the session had ended, it was only within a week or two, they were called back into a special session to repeal HB 477. Because when it comes to GRAMA, you have, if you try to restrict access to public records, you will have some opposition. You'll have opposition will be coming from the news media, because GRAMA is one of the great ways that the news media is able to access government records and determine what is happening with government actions that the news media then, of course, reports upon. There are many freedom of information advocates. They, of course, like to see what's going on with government and report upon that on blogs or just other various venues in order to see what transparent things are happening with government records. But then if you make the access easier, then you have this small problem that you may also be opposed by governmental entities, because the cost of access goes up. If you make it easier, there are more records being requested. It can make it difficult for governmental entities to take care of these things. And so GRAMA is always kind of this very interesting balancing act that is taking place. You have this balancing act between really the public's right to access to information concerning the conduct of the public's business, but then you also have the right to privacy for personal data gathered by governmental entities. GRAMA tries to strike a balance between those two to make sure that one doesn't outweigh the other, so that we're able to make sure that we have information that's accessed by the people to know what is happening with the government's business. But at the same time, there is information within those records that you want to be able to keep private, to make sure that government records aren't abused and that individuals' privacy rights are able to be kept through the privacy of those records being kept from access. Now, changes in GRAMA in 2019 actually was one of the more significant times where GRAMA changes were made. But I characterize them basically in these different parts. The first one, in which we are going to talk probably the most time about, is the creation of the Records Management Committee. This was really the first major change made to GRAMA in the way that this takes place since 1991. And so it's one that I want to spend a little bit of time to talk about what is it and how does it impact governmental entities and the access to records. The second part, there were some updates made in the process of requesting records. For those of you that are records officers, I think you'll be interested in some of those changes because they could impact how you are doing things. But the legislature thought that there were certain parts of GRAMA that really need to be kind of refined for the requesting of records, whether they're coming from individuals or also records being requested by governmental entities through the sharing records provisions. And then third, as always, there are always new non-public record classifications. One of my favorite parts of GRAMA is 63G-2-305, because there's basically, I would call it a laundry list of records the legislature has found that need to be protected, to be made non-public. And the list every year grows longer and longer and longer. And so I always just keep wondering if GRAMA continues as it is in its present form for 100 years, how long is that list going to be? Because basically each legislative session, the legislature hears from a different governmental entity that says these records need to be protected, these need to be made non-public. And so they just get added to the list, and the list continues to get longer and longer, which makes it fun. So, because yes, I'm an attorney and I find GRAMA fun. But let's start with this very significant change that's happened, which is the Records Management Committee. There were two bills that Senator Harper put forward. This is the first one we'll be discussing, which is Senate Bill 25. The House sponsor was Representative Adam Robertson. And this bill basically kind of goes back to what I call one of the basic ideas of the more things change, the more that they stay the same. It's one of my favorite quotes, and if we are to talk about the Records Management Committee, in some ways, the way that things have changed, they actually have become a lot more of the same. Because let's go through just a little history of the State Records Committee. For those of you that are not familiar with the State Records Committee, it basically has had two roles for the past probably almost 18 years, since 1992. Their role has been to hear records disputes when people request records from governmental entities. They are able to resolve those disputes and find for the petitioner or for the governmental entity. But they also have retention schedules, and so they have been operating like that since then. But prior to 1992, the State Records Committee was a little bit different, and in the history part is very interesting. So, for example, here on your screens is Utah Code 63-2-68. There was a major revision that happened later on. There were so many parts of 63, so you have letters added to them, but this was before that revision happened. But back in 1981, this is what the State Records Committee was composed of. There is hereby created a State Records Committee composed of the archivist, the state auditor, the director of the Division of State History, the Attorney General, and the Lieutenant Governor. And you can just kind of imagine what that committee must have been, because you have some, I would say, very important people in state government. The Lieutenant Governor attending, the Attorney General attending, the State Auditor. You have 3 of the 5 constitutional officers here on the State Records Committee. But then also you have the need for the State Archivist, which at this point is also the head of Division of Archives, and then also the Director of Division of State History. This statute is very interesting. You notice that it does not have any designees. It is actually made of those people attending that. And then also requirement that the Records Committee shall meet at least once every quarter for the purpose of reviewing the policies and programs for the retention and disposal of state records. And then the State Archivist was actually the Executive Secretary of the State Records Committee at that point. There was a change that was made in 1985 where I guess they kind of figured out that a few people get to be a little busy. For example, the Attorney General now is able to have his designee be there, or his or her designee. And then the Lieutenant Governor was replaced by a citizen member appointed by the Governor at the recommendation of the members of the committee. So you still had the 5 that were part of that. But then they also expanded a little bit more that the Records Committee meet at least once every quarter to review the policies and programs for the collection, classification, retention, disclosure, and the disposal of state records. So this continued until a very major change. Oh, and then also the duties was within 68.1 to review the designations made by a responsible authority and to reclassify any data on individuals or systems of data on individuals maintained by state agencies upon petition by the responsible authority, by the individual who is subject to the data, or by any interested party except as otherwise provided by law. Kind of again going back to this basic idea of the State Records Committee is looking at issues of retention, how the classifications are supposed to be done, and that was their main duties, what they had to do. Also, they were to initiate on its own discretion and designation the classification of data on individuals or systems of data on individuals maintained by state agencies except as otherwise prohibited by law. And then also adopt rules regulating its own meetings through the Open and Public Meetings Act and any of the applicable provisions. And then also make available to the legislative and judicial branches of state governments and political subdivisions of the state the classification review which it is authorized to perform by this act. Again, kind of going back to that basic idea that they're really looking at retention, disposal of records, how they're classified, not really looking at any disputes. Until 1991, it is HB 246 where we get the Government Records and Management Act, or as we is later put in the Records Access and Management Act as GRAMA is what it's called. It was passed in February of 1991, approved by the governor on March 18, 1991, but it was very interesting. It wasn't effective until April 1st, 1992. As a little bit of history, part of the reason why they did this is because this was such a massive wholesale change in the way that government records were to be managed through what would be an expanded role of the State Records Committee, and then also designations being made for private, protected, controlled records, public records, that the legislature passed the act and then had basically a 1-year period of time before it became effective, so that the 1992 legislature, when they came into session, would have an opportunity to fix any mistakes or things because they would have basically 1 year to take a look at the act and then make any changes as needed. So some of the things that it made for the State Records Committee, it said that they have to meet at least once every 3 months to review and approve rules and programs for the collection, classification, disclosure of records, review and approve the retention and disposal of records. So all these are very similar. But then also this extra provision, hear appeals from determinations of access as provided by section 63-2-403. This part about hearing appeals from the determinations of access really in many ways is what has defined the State Records Committee since that change in 1991. And so this is a listing of appeals that have been heard by the State Records Committee since it had this change for appeals from 1992 to 2018. Now, you'll notice 1992, only 2 appeals, and for the whole year, that would have been so interesting and so much fun because that's not a lot of appeals that made it before them. There was a little spike in 1994, went up to 17, but for the most part, up through to about before 2008, you never even had more than 20 appeals that were heard by the State Records Committee. And so if they're only meeting quarterly, and you divide that by 20, you can maybe have 5 appeals at a time. But by that point, they were meeting pretty much monthly. So even if you have less than 20 appeals, if you're doing that monthly, you maybe have 2 to 3 appeals per State Records Committee meeting. But then you can see the numbers right about, 2008, they started going up a bit. But then 2015 is when we really saw some big jumps. 2015, we had 34 appeals before the State Records Committee. 2016, 51. 2017, 50. And then last year, we had 63 appeals. So if you think of an appeal, each one, say if it takes at least 1 hour, because you give each side about 15 to 20 minutes to go ahead and make their arguments. The State Records Committee then has to do its deliberations in open. Some hearings actually for a single appeal have taken up to 2 to 3 hours if they're a lot more complicated. But with 63 appeals, this basically became what the State Records Committee was taking care of. They were taking care of these appeals regarding access determinations and things about retention and classification of records by other governmental entities were kind of put off to the side. Now, this has, of course, no bearing on the fact that I started in 2008 and it just happens to go up about then. I have no control over the appeals. I just hope that, in looking at this many appeals, that recognize that we, the Attorney General's office, we help draft these appeals, the decisions, but then the appeals are actually approved up by the State Records Committee members before they go out. And if there's any group that's I think of a great job that they've done, it's members of the State Records Committee, because some of them are volunteers, some of them are not even serving in any sort of state position or a public position, some are retired. And to have this many appeals come through is really taxing on their time. But they're willing to do it because it's an important part of state government to have access to these records, have these disputes being heard, and then reviewed by this neutral panel, which is the State Records Committee. So this was really the impetus of why the Records Management Committee change was going to be made, because the State Records Committee itself was having so many appeals coming through. The part about retention and about classification really was kind of relegated to at the very end of a very long day and say, well, let's kind of go through, let's talk about these things, let's get the approval. It's almost 5 o'clock in their session, shut the building down. So SB 25 comes through, and there are 4 things that it does. The first thing is that it modifies the membership and responsibilities of the State Records Committee. It then creates the Records Management Committee, but then establishes provisions for the administration of the Records Management Committee and transfers certain duties of the State Records Committee to the new Records Management Committee. As we go through each of these, the first one we're going to look at is how it modifies the membership and the responsibilities of the State Records Committee. The membership of the State Records Committee now includes an individual in the private sector whose profession requires the individual to create or manage records that, if created, by a governmental entity would be private or controlled. In other words, we like to be able to have this person from the private sector that's able to be there, that knows how records are managed, and that even though these are public records and this person's from the private records standpoint, we want to have that input from someone that's outside of government. And so that position is the same. They have made a change, and the State Records Committee, we're now to have an individual with experience with electronic records and databases as recommended by a statewide technology advocacy organization that represents the public, private, and nonprofit sectors. This is part of the realization that, let's just say, today's records are different than your parents' idea of records. Once upon a time when we thought of records and you come into an office and you say, I would like to go ahead and take a look at these records, usually have the person go back into a nice big file drawer, pull out a file, then they would take that file, put it on a copier machine and make a copy and give you a copy. Most records at this point are becoming more electronic records. They're in databases. And so on the State Records Committee, when you're having these disputes, we want to be able to have someone that's from the private sector that has this ability to be able to have experience in how electronic records are being taken place. Because sometimes the disputes that come before the State Records Committee, a person will say, well, I need to have access to this record. And then there's a question of how do they get access to that? How are they able to do that through a database? The third one is in a way, it's a new change, but it's not a new change because what has been in practice has been that we've always had the director of the Division of Archives and Record Services, or the director's designee, serving on the State Records Committee. That has actually been done under the provision that the governor was able to appoint a person to serve that position, and the governor, for obvious reasons, likes to have the director of the Division of Archives, or the state archivist, to be there. This has just been changed so that it's now in statute that the director is actually a member of the State Records Committee. The other parts that are still the same, we still have 2 citizen members. We have 1 person that represents political subdivisions as recommended by the Utah League of Cities and Towns, and then also 1 individual representing the news media. So again, we have this very interesting, I would call kind of a dynamic. And then you have people from the private sector and the people from the public sector that are serving on the Records Committee. You have some that are from state government, and you have someone that's from local government, but then also having someone that's from the news media. Because the news media, again, makes quite a few GRAMA requests, and here's this opportunity for a person in the private sector that knows news media, has been part of it, that they can be able to review these requests that are being made for records of governmental entities. And this is a nice picture that we currently have up on the website. We can see some of the individuals that are there, which is our fun, nice mix of private and public, and those that put some time in as members of the State Records Committee. The second part that it does, it also creates the Records Management Committee. Now, this Records Management Committee is now made up of the director of the Division of State History, or the director's designee. It used to be that member of the State History was actually a member of the State Records Committee, but now they are part of the Records Management Committee. You once again have the director of the Division of Archives and Record Services, or the director's designee. So this person will be serving both on the Records Management Committee and also on the State Records Committee. But then you also have 5 members that are appointed by the governor. And these are listed out as being a member of the Utah State Bar who understands public records keeping under GRAMA. So they will need to find an attorney volunteer that understands how public records work with GRAMA. A member with experience in public finance. That's going to be an interesting mix as part of that. An individual from the private sector whose principal professional responsibilities are to create or manage records. I'll be curious to see if, when that appointment comes from the governor, if we have that person be the same person who basically has the same criteria for the State Records Committee, also serving on the Records Management Committee. a member representing political subdivisions recommended by the Utah League of Cities and Towns, which is also similar to what we have with the State Records Committee, and a member representing the news media. So I would say at this point, since the SB 25 has not been put into actual law yet, how the governor will deal with this. Maybe he will have some of these be the same people that are on the State Records Committee, or because of how much time is being taken by the State Records Committee, maybe the governor will find different individuals to represent, for example, political subdivisions, the news media, someone from the public sector or private sector that basically has responsibilities for managing records. We shall see how this is implemented, but those are what's outlined in statute for the 5 members appointed by the governor. Now the other part, the third part, is that it establishes provisions for the administration of the Records Management Committee. Because the Records Management Committee shall review and determine whether to approve each schedule for retention and disposal of records, including proposed schedules submitted to the committee under 63G-2604 within 3 months after the day on which the proposed schedule is submitted to the committee. So there's a time span on this when it needs to be done, but also just the idea that they're really going back to what I would call originally the State Records Committee did before, which was approving proposed schedules, looking at retention, disposal of records. That is what the Records Management Committee is going to do. The committee may make recommendations to a governmental entity regarding the entity's management of records. As we reviewed through before, that was part of the original duties of the State Records Committee prior to 1992. And the State Archivist will provide staff and support services for the Records Management Committee. This is similar to the State Records Committee that basically the Division of Archives supports and provides staff for the State Records Committee and then also the Records Management Committee. And similarly, the Office of the Attorney General shall provide counsel to the Records Management Committee. I am just guessing that I will probably be the same person for those since I represent archives. But in any case, we have previously the State Records Committee had the Attorney General sitting as a member of the State Records Committee. We still have that, I guess, relationship between Records Management Committee, State Records Committee with the Attorney General's office by having the Office of the Attorney General providing legal counsel for both groups. And the fourth part, it transfers certain duties of the State Records Committee to the Records Management Committee. We've already kind of covered this, but is removing from the State Records Committee review and approval of schedules for the retention and disposal of records. And also removes the requirement for the State Records Committee to meet at least once every 3 months. We kind of joked about this, that they require us to meet once every 3 months, but pretty much the State Records Committee, because they have so many appeals coming through, they meet at least monthly, and there have been a few occasions where they've met more than once a month. So you look at these numbers and you see how the numbers go up, and it makes a lot more sense why the legislature thought it'd be a good idea to create this new committee to basically take care of retention, disposal of records, because the State Records Committee itself, they have a lot of things that they're doing. And it's important to have them concentrate on these appeals because the appeal numbers have definitely gone up over the years. Now the next major part we're going to talk about is the updates in the process of requesting records, because there were some changes that were made. This is now coming from what is called SB 108. Again, this is the second one from Senator Harper. This one has a floor sponsor of Representative Brad Daw. And what SB 108 does is that it modifies the right to inspect and copy records. It also modifies provision that a governmental entity is not required to fill a records request if the records are already publicly available. 3, it modifies restriction on sharing records of a publicly funded library. 4, it prohibits a records request from being submitted to multiple governmental entities. 5, modifies the provision relating to an award of attorney fees on appeal relating to an access issue. So let's go through each of these. Modifies the right to inspect and copy records. This is going to change provisions in what is current 63G-2-201. And I just basically took it seemed a lot easier to just take screenshots. This is coming from the bill, and you can see what the changes are. Again, the way that legislation works is that what used to be that has been changed is a strikeout. The new provisions are underlined, so you can see what has been brought in. It used to be that 63G-2-2011A was a very, or actually just one, a very simple statement that every person has the right to inspect a public record free of charge and the right to make a copy of a public record during normal working hours, subject to the provisions that are found in 203 and 204. But they expanded this to 1B to state that a right under subsection 1A does not apply with respect to a record to a copy of which the governmental entity has already provided to the person. So they don't have a right to get another copy. That is subject to of a records request that the governmental entity is not required to fill under 8E, which are actually the prisoner provisions. B3, that is accessible only by a computer or other electronic device owned or controlled by the governmental entity. That is part of an electronic file that also contains a record that is private, controlled, or protected, and that the governmental entity cannot readily segregate from the part of electronic file that contains a private, controlled, or protected record. Now this 1B, I guess 3I or 3, this is kind of a recognition, as we mentioned a little bit earlier, that records are not the same records that our parents had. They aren't in a file drawer. The legislature is trying to find a way to, I guess, kind of clarify that many of these records are going to be electronic records, but oftentimes when you have electronic record as part of a database, you're going to have information that is also private, controlled, or protected. So when you have this right to be able to just come in, inspect the record free of charge, well, what if it's in a database and you have information that's in the database that is non-public? And this change is just kind of clarify and make it a little bit easier for governmental entities to be able to say, yes, you have the right to be able to come in, take a look at this. However, because it's in a database, we need to segregate some of these records. We need to take some additional steps. And this clarification on 201 is just making that clarifications because records are different than what they were before. It also modifies the provision that a governmental entity is not required to fill a records request if the records are already publicly available. Sometimes we call this the library exception. But this is also bringing into account that there are a lot of records that are available online, and that you have a person that comes in, wants to have a copy of the record, and it makes it a little bit easier for the records officer to simply say, well, just go to the internet. Here it is. It's right here. And because most of these records are, again, are electronic, and a lot of these are being made available online. We have, for example, the transparency website for the state of Utah, where you can be able to look up money that's been paid, money that's been brought in, and basically to see where money has gone. You can be able to go to the transparency website much easier than trying to pull something up off of a database. You also have things with the public notice website where you can be able to see meeting minutes. You can be able to get copies of audio files of the actual minutes. That because these online resources are there, we want you to be able to go to those resources first to really kind of make it easier on the records officer. That the legislature has really tried, I think, honestly, in many ways for the last few years, to try to make these records more accessible, and not because again we had that balancing effort that if you make it more accessible, then it's more difficult for a governmental entity to provide the records because it takes time. This is making it more accessible, but because they are online, that any person can be able to access them, it's much easier, simpler, and economical for people to get records through this than actually having to make a GRAMA request or a records request to get a record that you can just find on the internet. It also modifies the restriction on sharing of records of a publicly funded library. And this is just one of those exceptions that someone found in 63G-2-206, which is our sharing record provision between governmental entities. And it basically just clarifies that says a publicly funded library may share a record that is a private record under 302 with a law enforcement agency if the record is a video surveillance recording of a library's premises and the law enforcement agency certifies in writing that the law enforcement agency believes the record will provide important information for a pending investigation into criminal or potentially criminal behavior, and the law enforcement agency's receipt of the record will assist the agency to prevent imminent harm to an individual or imminent and substantial damage to property. This was just making sure that law enforcement, if there's something that a publicly funded library has involving video surveillance, law enforcement needs to be able to have access to that so that they can do what they need to do in law enforcement. And so just to make sure that that exception loophole was closed, that's why they put that into the sharing record provision, to make sure that law enforcement has access to those things so that law enforcement can do what they do best, which is prosecute those that do criminal violations. The fourth one prohibits a record request from being submitted to multiple governmental entities. And this was actually something that came up with the State Records Committee during this past year, that we had some appeals that came before the State Records Committee where the governmental entities didn't even know that they had a records request being made of them, because a person would make the records request, they would do it by email, and it would copy 15, 20, 25 different governmental entities. And so if they just saw the multiple requests being made, they just thought, well, we're not really the person that's the governmental entity that's being requested. We're just being CC'd on these emails. And then they get a letter from the State Records Committee saying, oh, by the way, you haven't responded to this records request. You have an appeal that is now pending before the State Records Committee. You need to show up. And so the legislature thought that would be good to go ahead and make a change. And here's what the change says. A single record request may not be submitted to multiple governmental entities, but it is not to be construed to prevent a person from submitting a separate record request to each of the multiple governmental entities, even if each of the separate requests seeks access to the same record. This is taking care of that whole problem of where you have 15, 20, 25 governmental entities all getting the same exact record request for the same type of record, but being held by different governmental entities. But they didn't really know that they were getting that. So it's really kind of closing that loophole that if you want to go ahead and make a request of multiple governmental entities, just copy your email, so to speak, and to go forward, and that would make it better. The fifth part, it modifies provisions relating to an award of attorney fees on an appeal relating to an access issue. And this is under the provisions which are found in 63G-2-802. This doesn't come up very often, but the reason why 802 is part of GRAMA is the basic idea that, say for example, not that any governmental entity would do this, but we lawyers always think of worst case scenarios. What if a governmental entity decides that it wants to make sure a person doesn't get access to a record that should be a public record, and they basically throw roadblocks up all the way, but in all honesty, GRAMA makes it so that record should be a public record. This provision basically allows that a district court may assess against any governmental entity or political subdivision reasonable attorney fees and other litigation costs reasonably incurred in connection with a judicial appeal to determine whether a requester is entitled to access to records under a records request if the requester substantially prevails. And the substantially prevails is a very important part, and kind of think in terms of if there was really no legal standing for that governmental entity to say no to that record, and everyone, including the State Records Committee or the District Court, all say, no, you absolutely should have given this. You might get that finding of substantially prevails. And if you had to spend money on an attorney to be able to get those records that you should have had in the first place, the district court has that ability to award those reasonable attorney fees. So it just changes that wording from a denial of a records request to determine whether a requester is entitled to access to records under a records request. The third part of what was done is the new non-public record classifications. And these, again, is part of that whole laundry list of things that are changed, things that are very specific, and so probably aren't going to be things that affect most of you in political subdivisions, but some it may affect because it's very specific. For example, records submitted to the Department of Insurance in the process of obtaining a certificate authorizing a company to act as an insurer are now considered protected records if properly classified by the governmental entity. So in this case, this is only for the Department of Insurance. The Department of Insurance is required to regularly examine captive insurance companies operating in Utah. The captive insurance company is one that is owned or controlled by those insurers, but the records relating to those examinations are now protected records. It's added to the laundry list. Again, most of you probably will not be affected by that, but the Department of Insurance felt that these were important provisions to put in as protected records. For this one, this is the records for the Division of Occupational and Professional Licensing. These records that are in a database that manage prescriptions and controls substances, they may be classified as protected records. That one should be pretty obvious why. This includes information about Doppel visits associated with deaths caused by an overdose or prescribed substance poisoning. Apparently there were records requests being made of some of those type of records. And thank you, more water. That you want to keep this information protected. And again, the distinction between protected and private is an important one. Private records, if the person is the subject of the record, they can be able to get access to a record. But if something is a protected record does not give the person who is the subject of the record access to that or people that are related to that. It's an added provision, but then also protected records, while many records that are private records, it says these records shall be private records. The protected records provisions of 305 say if they are appropriately classified by the governmental entity, meaning that you have discretion that is given to the governmental entity to make those determinations of whether those records should be given out or not. And so putting them in that protected classification under 305 gives it, shall we say, the added privacy benefit of things that basically the legislature believes that should be kept private, non-public in a protected setting. That is the same one. So the next one is records related to injuries involving amusement rides may be classified as protected records. Owners are responsible to report amusement ride injuries, and these reports are protected. Now, there are so many amusement rides out there that makes you kind of wonder, but apparently for some reason there was a need to protect these type of records. Maybe it's more so the privacy of the individuals that are involved in these. They just want to make sure that, of course, they would have to be handled by a potential governmental entity or the state or someone that oversees these type of rides. I, of course, just kind of had my idea as seeing one of these, like, oh my goodness, this is the amusement ride and fell off. We need to keep all these protected, probably medical records things, but that is a provision that was added during the 2019 legislature because that's very important to them, to any records involving amusement ride accidents. Another one is a candidate's residential or mailing address to the extent that the candidate provides another address or phone number where he or she can be reached may be classified as a protected record. Now this is very interesting because again, we want to be able to have access to people that are running for office. But then the question comes up, well, if a person is running for office, do they all of a sudden give away their privacy, where they live, what their address is, what their phone number is? Because what if, for example, that person gets elected, congratulations, everyone has access and knows what their personal phone number is, what their personal address is. It could become very difficult for a person for example, if someone is serving in a political office, they need to be able to have a way to have them gain access to them. For example, I live in the city of Draper. The city of Draper has email addresses for each of the members of city council and also for the mayor. So you can be able to reach out to them. There's also phone numbers that go into Draper City. But for their home address or home phone numbers, you can see how those things could be abused. And people just calling over and over again, Mayor, can you take care of this? Mayor, can you take care of this? And this is a change to be able to allow that we have elections. We want people to run for election, but not at the expense of having still some personal privacy. You need to be able to have access to these candidates, but at the same time, that does not mean you have to have access to their home address and also their home phone numbers. Now, one other one which kind of throughout you might have heard in the news is involving Brigham Young University Police. There was a change that was made in the definition of what is considered a governmental entity. And this goes to a case that maybe you might have been following for the past 2 to 3 years, in which the Salt Lake Tribune requested records from the Brigham Young University Police Department. Well, the Brigham Young University Police Department is part of a private university. They are not a governmental entity. And so the request came to the State Records Committee. The State Records Committee dismissed the appeal without even a hearing, saying, well, they're not a governmental entity. They don't even have a retention schedule. We really don't have any oversight of them, so we can't order them to give out the records. And so the case went to district court. The district court, at least for a motion to dismiss that was filed on behalf of the State Records Committee, said that there is an issue that could be argued on either side, that Brigham Young University Police, because they have police powers, they might be considered a governmental entity. Not the whole university, for example. Brigham Young University is absolutely a private university. They do not take tax funds. And so that argument is not being made. But because of the relationship of police power and Brigham Young University Police, the judge said that this is an issue that could be found in favor of the Salt Lake Tribune, finding that the police department is a governmental entity as far as records requests made under GRAMA. That was appealed to the Utah Supreme Court. It's what's called an interlocutory appeal, meaning that there are other issues, for example, what records should be given out. Those issues have not been resolved, but the Utah Supreme Court took the case. But we have this change that is made in the statute for a definition, 63G-2-10311B VI. A governmental entity also means a law enforcement agency of a private institution of higher education if the entity or division has been certified by the Commissioner of the Department of Public Safety. Question has been asked of me a few times since I represent the State Records Committee and Archives. What will this do to the Supreme Court case? And I think in many ways, because if this is applied, for example, to Brigham Young University Police Department, it kind of makes sense that if they are being considered a governmental entity, the issue really is not going to be left at the Supreme Court. So I'll be curious to see if there's just a dismissal of that part of the appeal before the Supreme Court. They could make the argument, since this records request was made 2 to 3 years ago, that statute should apply. But in any case, as for anything going forward, if records are being requested from a private university, higher education, and so you would have Brigham Young University, Westminster College is also another one that has, I believe, a police department that's been certified by the Commissioner of the Department of Public Safety, that those records, because you're dealing again with police power, which is inherently a governmental attribute, that they can have access to that if you make a GRAMA request. For those things that are public records, obviously some things that would be classified as non-public would continue to be that way, but GRAMA would apply to those records even though it is a private institution of higher education. So I always kind of end off with the idea that, is GRAMA, is it rocket science? Do you need to be an Einstein to figure out how GRAMA works? And I hope not. The legislature has put together the structure of GRAMA and also archives in such a way that hopefully any person can go ahead and take a look at it and understand it. You don't have to be a lawyer, you don't have to be an Einstein to figure those things out. At the same time, always have a nice little disclaimer. If you don't know the meaning of a statute, you can always consult your own legal counsel, who will then make their best attempt at understanding the statute. And my presentation is, of course, my attempt at understanding what the legislature meant with their changes and should not be solely relied upon for your legal decisions. If you are with a governmental entity, the best person to ask about how do you interpret this statute, it should come from your own lawyer, and not simply just say, oh, I heard a webinar, Paul Tonks said this, and therefore it must be true. I would love that to be the case, but unfortunately, I'm not always right. And just by the way, for those of you who are below the age of 40, the picture is of Raymond Burr, who played Perry Mason from 1957 to 1995. I think as lawyers, we always kind of consider him the smartest lawyer in the history of television, because he could just walk into a courtroom and win every single case. And some of us might have grown up on watching some of those and thought, that's what I'm going to be as a lawyer. But don't worry, that's not how it works. And we will not judge you if you don't know who that was in the picture down below. So those are the major things. There are a few minor things. The Divisional Archives is also putting out basically, I don't want to say a statement or a letter that goes through and details every single change that was made in that. But that would take more than 1 hour to go through everything else. But I just want to say thank you very much for those of you that listened through. And at this point, if there are any questions, you have that opportunity to be able to send those questions along, and I will make my best attempt to answer those questions.
Okay, so we do have a question. Kendra has a question about the first point you covered in section 2.
Okay.
Kendra, what is your question? There's about a 20 to 30 second delay between what we say and when they see it.
Oh, I see. Okay, so we are going back to, you said second section.
Second section, the first point he covered in section 2.
Section 2, so let's see, so what points are those? And they can see all this, don't they, too?
Yeah.
Okay, so section 2 is updates in process of requesting records. Is that right?
Uh-huh.
Okay, and so let's go down to when it hits number 2. So the first point modifies the right to inspect and copy. Okay, so what's the?
She hasn't actually told me the question yet.
Oh. we can try. Let's see. So slideshow from the current slide. So there we go. So it's right there. The first point modifies the right to inspect and copy records, which would be this part here. Okay.
Okay, so
the question is,
she says, I think the intent is that they can't come in and view records in a database if there are private or protected records that can't be separated.
Yes. Can't look on it. It's kind of hard to look on the computer screen and take a look at it when other stuff is there. It has to be segregated out. And this helps with that, definitely. Although, kind of joked, it'd be great if you go ahead and pull it up on the computer screen, take out your little whiteout and just kind of mark on the computer screen and kind of cover those things over, but that doesn't quite work as well. But that's how you do it in the old days. You'd pull out the file drawer, you get the file, you make a copy, and you'd go through and you'd black out those things that were non-public so that you can't see them. But if it's on a database and it pulls up on a computer screen, you can't pull out the whiteout and white over things. There has to be some way that the governmental entity can be able to get that record, put it in a different type of medium, because obviously if it's got non-public stuff, you can't have them just look at it on the computer screen. They will probably have to print it or be able to run it through a PDF and then take some things out. But it makes it a little bit harder, absolutely, for a person just walking in and inspecting a public record free of charge. But that's the age we live in. A lot more things electronic, a lot more things are in databases, and I think I saw a figure at one point that like all government records are up to about like 95% are electronic now. So it's kind of fun over the AG's office because attorneys were always behind the curve, shall we say. But we had just file drawers upon file drawers, and they're taking them out from the Hebrew Wells building because we just don't keep physical files on records anymore. They're all electronic. So
okay, Kendra says but.
But okay.
I just want to be clear that this doesn't mean I don't have to provide the record just because it can't readily be segregated from the record that is private.
Correct, correct. Yeah, absolutely, because there is another part of, I believe it's in 201 that says, the fact that it is an electronic record should not be a reason for denying access to the record. So when you take that and put it in with what's here, they still should have access, but it's not just that readily, here I can just inspect it because you have it. You still have that opportunity to be able to segregate the records to make sure only the public information gets there, but you cannot use the fact that it's an electronic database as a way to say, sorry, there's other stuff, you can't get to it. Absolutely.
Great, thank you. No more questions so far. We do have, Pat says, very interesting webinar. Thanks, Paul.
Oh, thank you.
Tim
Thank
says,
you.
Thank you, very informative.
Oh, you can just keep reading all those as long as you
Those
want.
were the only ones.
Oh, two kudos are good. That's
Yeah.
good.
But yeah, I don't see any more questions coming in.
Well, and I had worries about taking up a whole hour, but I'm pretty close to that, so that's
Yeah.
not bad.
Yeah.
Good.
So, okay.
Well, if there are no other questions, I just want to say thank you so much for my yearly annual coming back and doing this. Again, this information is going to be provided, well, the webinar itself is provided by Archives, which has basically the PowerPoint that I have that's on there. But then also just we will have things that are given out by Archives, where they actually show which statutes have been changed, a little more details on that. And of course, Archives is a great resource for you if you have questions about, I'm not quite sure how this works out, just call them up and they'll be able to help you with those things, because that's what they do. Try to make this records management idea and retention and classification and disposal of records done in such a way that we take care of the things that we need to, so that government can be transparent and people know what's happening, and also protect that information that needs to be kept non-public. Thank you very much. Appreciate it. And until next year, thanks very much.